Hello and welcome to all my participants across EPS channels in YouTube, Twitter, LinkedIn, and Facebook to your one-stop shop or the one-stop show, which gives you incisive analysis on a topic of interest from the world of finance and payments. We have been giving you these shows day after day on all weekdays. Today's topic of discussion will be on tackling NPA crisis with IBC. That is the Insolvency and Insolvency and Bankruptcy Code. To discuss about the topic, please join me in welcoming a very, very experienced banker, Srimati T. Latha.
Thank you so much.
Srimati T. Latha is a former MD and CEO of Dhanlaxmi Bank. Under her leadership, the loss-making bank made profits for 5 consecutive quarters. She also steered the bank clear of the PCA framework. Prior to Dhanlaxmi Bank, Srimati T. Latha spent over 35 years with Punjab and National Bank, where she handled multiple responsibilities, including branch management, regional management, and national level credit management, handling a portfolio of approximately INR 40,000 crores. That's a lot. As a general manager in PNB, Srimati T. Latha was also in charge of credit operations dealing with large corporate credits. She has handled finance, credit, strategic business development, people management, NPA resolution, and audit. She holds an MBA degree with specialization in finance management. She has also completed a master's degree in literature and passed CAIB and the limited insolvency examinations. Good afternoon, Madam Latha, and a very warm welcome to our show.
Good afternoon. Thank you very much for a nice introduction.
Thank you very much for coming and talking to us on the Insolvency and Bankruptcy Code. So important for all our audience, all our participants to know how we are doing in that. So before we get into the IBC, I'm sure a lot of the participants would like to know, something that is like just from the oven. It's hot from the oven. RBI governor has just about a couple of hours ago came and announced recommendations of the MPC, Monetary Policy Committee. Any good points you picked up that can help the distressed business and economy, Madam?
Yeah, as you said, it's just a policy which has been just announced.
Yes.
I just noted a few points.
Yes.
I mean, not complete in detail, but just a brief of that.
Yeah.
See, one is that RBI has decided to amend the priority sector lending guidelines. See, they've stated that the stressed MSMEs will now be eligible for restructuring debt, provided the accounts are classified as standard till March 1, 2020. See, earlier we knew that once the account is restructured, automatically gets a tag of an NPA. And then once an account is classified as NPA, then the chances of the industry surviving or getting further credit for an MSME is very difficult. The central bank has also amended the priority sector guidelines, and they said there will be no regional disparity in that. And all of the thing will be startup industries will also get the priority sector attacking. Another thing, what they have done very well now is they've also announced some measures to ensure the soundness of the banking system. They have said that in order to implement a resolution plan without change in the ownership and respect of personal loans by classifying them as standard assets, subject to certain conditions. And for this, I think they'll be forming a committee which will be headed by Mr. K.V. Kamath to make recommendations for this kind of a resolution plan. And one very important announcement which they have made today is that they'll be giving some additional special liquidity fund to NABARD and the National Housing Bank. So because you see the liquidity is really in short supply today, so they said to enhance the liquidity support for the financial markets to further ease their financial stress caused by the COVID-19 disruption and to improve the flow of credit and to deepen the digital payment system, facilitate innovations. For that, they have said an additional special liquidity facility of 10,000 crores will be provided to NABARD, that is rupees 5,000 crores and 5,000 crores to the National Housing Bank. These are some of the few things which I just noted it down. And I'm sure this will really help our participants.
Thank you, madam. I think that's very important because it's just come out. So obviously we don't have too much of details in front of you, so you don't have that. And that you have picked up these 3 good points, and updated our participants who have just about, perhaps coming to know about this. It's a good thing. It's a great, I think, from what you said, I think these announcements are excellent. And once we see the more details, we'll be able to gather more information. So, ladies and gentlemen, our topic of discussion today is the Insolvency and Bankruptcy Code 2016. IBC is the bankruptcy law of India, which seeks to consolidate the existing framework by creating a single law for insolvency and bankruptcy. The Bankruptcy Code is a one-stop solution for resolving insolvencies, which previously was a long process that did not offer an economically viable arrangement. The code aims to protect the interest of small investors and make the process of doing the business less cumbersome. So, it got, like I said, in 2016, it came into being. So not too far. And just to give you statistical, just a quick background before we get into in discussion with madam, a total of 3,774 cases have been filed. This is as of December into IBC. Of these, 43% have closed by way of resolution, liquidation, or other means, total lying around total about 1,604 cases. That's still left out. The remaining 57% or 2,170 cases are still going online, many of which have exceeded a 330-day maximum time limit set under the bankruptcy law. So the law also says that any resolution must be done within a timeline, within a time period, which is very good. It's just not that it is just carried on endlessly. So that's a good part of this. Of the 1,604 closed cases, 14% have found a resolution. Okay, that means they have actually been resolved. The rest have either gone into liquidation or some other things. So while 14% may sound to be, not too big, but at least there's a beginning out there. And most importantly, 221 have ended in approval of resolution plans. That's a good sign. So where there was nothing before, now there is the IBC code brought in 2016, and there is some hope, some resolution mechanism that comes such that the business survives, the creditors get their money, and most importantly, the employees retain their jobs. That's very important. So the law is extremely good. So let's get into some understanding more about it from Madam Latha. So, Madam, the IBC is considered to be the biggest reform, next only to maybe GST. GST was the big reform, and maybe IBC could be considered the second best. Can you tell our participants how this landmark piece of legislation makes a departure from what we call as the debtor in possession to creditor in control model? If you can also mention these two terminologies, what does that mean?
Yes, Mr. Krishna Kumar, I fully agree with you that this is one of the very important economic reforms which have taken place in the last few years. And this real legislation has really enforced a true dictum that from the debtor in possession to a creditor in control has happened. Once a insolvency petition is filed in the court and it is accepted and admitted, the existing board gets automatically suspended or superseded, and the resolution professional appointed by the NCLT takes over. This really gives an opportunity for the company to start really functioning. Earlier, what was happening, if you see, is in spite of the fact that the account had become an NPA or the account would be in huge distress, the debtor continued to be in charge of the company. That is why if you see when the Banking Law Reforms Committee, when they started this exercise of finalizing for this IBC code, they made a very clear thing that as long as the debt obligations are met, the equity holders have complete control over the company and the creditors have no say in the running of the company. But the moment there is a default, it is for the creditors to take over the company, and the equity holders should have no say in the company. Because prior to this, nothing such thing was happening. It was only the debtors, in spite of the fact that the Reserve Bank of India and the Government of India brought in guidelines like S4A, your SDR, your CDR, your SICA, everywhere the promoters continue to stay and enjoy, not really bothering whether the efforts of all these schemes which are brought in for the improvement of the company were really taking place or not. And the bankers, the financial institutions, the operator creditors were really left, just wondering what is to be done, because it was not practically possible to sell a company unless it is in the hands of the creditors. Secondly, there was a lot of asset stripping. There was a lot of misutilizations of the funds which were happening. But now that the creditors have taken control, I think it's a very, very good sign that this registration has brought in. And I think going ahead, it will really have a lot of importance attached to it, and which I think we have seen in the various cases which has happened. But because the creditors were in control, that they were able to do so many resolutions, the plans were able to take place and really get fructified into new accounts. And as you said in the starting, the main reason for the IBC is that it should go for a resolution plan, and the liquidation should be the last resort, because in an economic country like ours with a lot of economic stress, the employees and the workmen, their job also should be equally safe.
Thank you, ma'am. So ladies and gentlemen, I hope you are able to appreciate the law, which the IBC law, which says that from the earlier regime, the earlier times when debtors were in control and the creditors were looking for their money, they were not getting that. So now that has changed, and they have brought the creditors in control, such that they are able to, at least get some amount of their money, or maybe the full money, and the company continues to work to do its business and retain, employment also remains. So, madam, how would you rate the first 3 years of journey of IBC, and has it managed to make a permanent positive change in tackling this huge, humongous problem called NPAs, non-performing assets?
See, let's say accept one thing, that it's a very dynamic situation. The first 3 years we have seen a lot of this, it's a roller coaster ride with a lot of ups and downs which have taken place. At least one thing is that before this code came into play, the financial creditors had no say in the matter. Now the financial creditors have a lot of say in the matter, and there seems to be a light at the end of the tunnel. And if you see in the last 3 years after this code was implemented, even the global index of the ease of doing business, which was the 100th place in the year 2018, has now improved to the 63rd place. I think it's a very commendable one. That's a great achievement. And one of the parameters based on which this index improved is that the insolvency resolution parameter has come up from the 108th place in 2019 to the 52nd place in 2020.
Yeah.
And as you mentioned in the beginning, that more than 3,600 cases have been referred to the IBC, out of which more than 2,000 cases have been resolved. And I think one of the very good things which the Reserve Bank of India, the Independent Advisory Committee suggested in the year 2017, June, was to take the top 12 cases of the country which were in default to the IBC, and the second lot of 29 cases, which I think constituted maximum to the 42% of recovery which we are talking of. Because they constituted nearly 25% of the total NPA of the banking system.
Right.
Which is more than 17 lakh crores approximately.
Yeah, okay. That's a humongous, this one.
It's only a starting point.
Yes.
If you see that, the only thing is, again, as you were also talking, is that we are not able to stick to the scheduled timelines which have been prescribed in the IBC. But again, as I said, it's a very dynamic thing, because there are a lot of teething problems being faced by the various adjudicating authorities, whether it was the NCLT or the NCLT. And ultimately, many matters have gone to the Supreme Court, and the Supreme Court has clarified a lot of decisions. So, if you see, even one more thing which I should really appreciate with the government as well as the regulator is that they are proactively keeping on updating the things as and when they realize that there are a lot of issues which could not get sorted out earlier. And one of the recent one, if you see, is a law which has been provided framework for the insolvency resolution of systematically important financial service providers. That is, of course, excluding the banks, which includes the NBFCs of 500 crores and above, including the IFS, HFCs. So I think these things now it will start stabilizing, and I think we have good hope that maybe in the next couple of years, maybe once the pandemic is over, we should really be able to see a lot of good recoveries happening through these IBC model. And they have also learned to evolve from the various challenges which they were also facing, because even today we see the number of courts are less, the litigations are more. I think all should get sorted out in the next couple of years time at least.
Yes, thank you. So yeah, ladies and gentlemen, it's only in 2016 such a massive reform has come. And like any other massive reform from the government, it takes time. It is not possible to get a good resolution right from beginning. GST has its own turn of many problems, right? But they have been overcoming that very regularly by regular meetings and frequent updates. And so is the case with IBC. I'm sure 3 years is too short a time for us to judge based on the numbers that I gave it to you before the start of the program. Madam, the IBC has shifted the focus from bankruptcy to turnaround, right? And that's a very important thing, that if a company is going bankrupt, just let it go. That was the earlier and the promoters were like almost having the same lifestyle. But now things have changed. Okay, can you tell how IBC empowers creditors to rescue a company that is a corporate debtor when it experiences serious threat to its life?
As you said, that IBC's basic idea has always been to restructure or ensure that the proper resolution takes place in a particular company. We are not interested in just liquidating a company or putting it into bankruptcy. It doesn't give any sense of purpose to anyone or anybody in the process. So the IBC has ensured that when a company has been admitted to the insolvency, as we have already stated, the creditors take possession. Creditors through a resolution professional. The resolution professional takes charge of the company, and along with the committee of the creditors, he ensures that there is a viable resolution which can take place to the best possible extent. He calls for the expression of interest. He ensures a information memoranda to be done. And he also ensures that there is a lot of things which go around to the assets of the company retain their value. The company continues to be an ongoing concern, because earlier what was happening is when the promoter knew that nothing is going to happen, he was not bothered. This person would ensure. And also now, if you see, the IBC has also seen that there are issues, and they've also brought in that the committee of creditors earlier had to give minimum 75% had to approve a resolution plan. Now they brought it down to 66% because a smaller creditor should not come in the way of a proper resolution. There's also about only 51% required for the routine matters. And they've also brought in now that even the other creditors, like a home buyer or any other creditor, can come in through an authorized representative to be presented. All these will ensure, because nobody wants a company to go down the drain, especially a company which has been running, say, for 20 years or 30 years, just for certain reasons, because many of the companies in India which are really going bad, at least is my view, is because of the over leveraging and lack of control by the top management. So these things do get addressed, and there has been a lot of benefits, I would say, because abroad, if you go even today, they are more into straight away going for the bankruptcy. They don't go for a resolution plan. And this also gives opportunities for the employees to remain and the economy of the country also to improve, because any company which continues to survive definitely gives impetus to the economy of the country.
Yeah, that's true. So,
and one advantage is even the promoters today.
Yes.
They realize that they have to be more careful in running a company.
Absolutely. Very important. I think they just can't get away.
Exactly.
Earlier, the thing was to start, get a good valuation, and then, whatever they get out of that. But that has so this IBC tries to mitigate that issue. So, ladies and gentlemen, we are talking about IBC and its impact on NPA, which is a topic we have talked about. NPA is one topic we have had with many subject matter experts, and we did talk about it in length. So IBA perhaps is one solution that is out there. While I continue to have discussions with Madam Latha, I would like to open up this session for question and answers early, because I'm sure that this is a subject of utmost interest to many of you who are in the banking and financial world. So you may want to ask questions. So please put in your questions in the Q&A box, or if you want to ask a question directly to Latha, at her discretion, she may be willing to answer or not. That's up to her, and she will give you a direct answer without having to go through the chat box. So look forward to some very interesting questions from you. The Q&A box is open. Please do send in your questions early so that we can take as many questions as possible before we end the show. Madam, from your experience, tell us in brief the most critical elements of an effective corporate insolvency resolution plan.
Yeah, see, there are quite a few critical elements for the corporate resolution plan. The first and the foremost is the identification, as we said already, we go to the insolvency admission, is even the resolution professional who has been identified should be really very competent and capable. We do have a lot of resolution professionals who have taken the exams and who have passed, but the experience is not to that extent, because I mean, we also cannot blame any individual for that, because the corporates which are in the pipelines are huge amounts, like account of 40,000 crores, 30,000 crores, 25,000 crores. Though he may take the help of the other resolution professional and other professionals to help him to run the unit, but unless he himself is fully aware of such a thing, it's going to be exceptionally difficult for him to run. That's what I would say. So I think we do need to have more kind of a training. Maybe some of the institutes can even think of training these insolvency professionals, so that when he prepares an information memorandum or when he is analyzing a resolution plan, I agree, the resolution plan is to be finally assessed by the committee of creditors, but still to know the various inputs which should go into that, I think it really helps with the resolution professional who is being appointed is a very competent person.
Yes.
Secondly, I should say that, see, the problem we have been facing today is that many of the industries which are going for the resolution plan do not see the light of the day, for the simple reason is the amount involved is huge and there's not sufficient capital available in the market to invest in these kind of accounts. Also, there are many cases, like if you see the power industries and all that, which have gone for these NCLT cases, the agreement which these people had signed at the time of executing the project, and today what is the amount that they are going to get from the PPAs are, the differences between heaven and the earth. There's a lot of difference in the amount, because when I set up a project, if I think I'll get 20 rupees per megawatt, and today if I'm told I'm going to get 2 rupees or 3 rupees, the project becomes very difficult for it to be a functional. Similarly, I think the timeline, again, it's again and again a matter of concern that we are not able to stick to the timelines. Fourthly, the question again is of today, if a company is purchased by XYZ, what happens to the contingent liability? What happens to the ED and the PMLA Act is not very clear. Of course, now the Supreme Court is considering one case in which the Bush and Power and Steel account, which JSW had agreed and has finalized for the resolution applicant. The ones that matter is decided. I think a lot of light will be thrown regarding the ED and the PMLA's job in this, because nobody wants to take over a company and tomorrow find the ED comes and says this is attached by us, or the PMLA comes and says this is attached by us. Similarly, I think, a lot of countries, like especially UK and the European Union, they have what is known as a packaged insolvency proceedings. In order to save time, in order to really know, because X may know how a company is, you can always discuss, finalize a package, come to the COC and tell them this is the package. And I think that will save a lot of time. And I think you'll get the best out of it for the economy as well as for the company as well. I think these are some of the critical inputs, I should say, for a resolution plan to work. Of course, there are a lot others, but these I felt were some of the basic ones which can be considered.
Sure. So you talked about the professional, so my question to you is, and I'm sure our participants would like to also to know, who are these professionals? Are they some kind of chartered accountants? Are they industry people? And is there some kind of a certification they have to undergo to become a resolution professional?
Yeah. See, you can be a chartered accountant, you can be a company secretary, you can be a graduate with a minimum of 15 years of chartered accountant, of course, with the 10 years of experience, and a graduate with a minimum of 15 years of management experience. They have to pass what is known as a limited insolvency examination, which is conducted by the IBBI. Once they pass that examination, which I had done earlier, but I could not get registered as a insolvency professional because you cannot be in a full-time job. And I had cleared it about 2 years back when I was working, and that's the reason I've not got myself registered. After that, now you have a online course also, which is supposed to do for a particular number of hours. Then you get yourself registered with an insolvency professional agency. And once you're enrolled with an insolvency professional agency, you will apply to the IBBI, the banking board, and get yourself registered as an insolvency professional.
Okay.
So the examination is not a very easy examination, because from what I've heard now, earlier I don't know how it is, though I've cleared it, that the percentage is not, I mean, it's quite a tough exam. So people who are really competent only can go through it. But again, since it is only a theoretical paper, I think we need more of, that's the reason I was saying we need a more of this practical experience to be given to them, so that they are more competent enough to take over the cases.
Yes, that's correct. That's true. So, and also you talked about the timelines, the 330 days time limit was kind of fixed. So that the claim was that this would be a process in which the banks would get the best recovery possible in a short period of time. So while firms that need assistance to return to viability would not be unduly penalized, and that was the kind of context that was set. So do you see a lot of cases going beyond this 30 days?
You see, actually, if you see when even the IBC code was formed in 2016,
yes,
the timeline given even for the adjudicated authority was only 14 days time from the date of application to the date of admission, excluding, of course, the period which they were given for rectification.
Yes.
But today, I don't think any case is getting admitted before 3 to 4 months.
Oh, okay.
The time lag starts there itself. As I said, again, one of the reasons is because we have very limited NCLTs. We just have 10 NCLTs as of today, 10 or 11 NCLTs today, and only 1 NCLAT.
Okay.
Secondly, after that also, as I said, in the first 3 years of the journey which we've been having, there's a lot of cases, there's been a lot of litigation. Each one, because once I feel my company is going out of my hands, I'll definitely try to, file a litigation here, file a litigation there and all that. But as I said earlier, many of these things have already been sorted out by the Supreme Court in the various court judgments. And once these court judgments are there, and if the latest one in case of Bhushan Power also comes in, I think many of these issues will get resolved, and maybe in the near future when new cases go up, they will not have so much time lag in them as we have been facing. In fact, if you see, there's a Bhushan Power case which I'm talking of. The case was admitted, was filed in the year 2017, June, when I was still in Punjab National Bank. And still today, it has not seen the end of the tunnel, light of the tunnel.
Yeah, we do see a lot in the news about it. Keeps coming and going, so we will talk about Bhushan perhaps as a case study, provided we get a little time on that. So let's let me once again appeal to my participants. Please put in your questions as soon as possible. Otherwise, we'll run out of time. We already passed the half an hour mark. So please put in your time early. Put in your questions early so that I can take it across. So while we wait for some questions to come, Madam, from your experience, tell us in brief the most critical elements of an effective corporate insolvency resolution plan?
No, I think we discussed that just now, if I'm not mistaken, that the critical elements, as I said, will be the appointment of insolvency professional.
Okay, yeah, yes. Yeah, we did talk, and the timelines and
yeah, exactly.
That's
the timelines
correct,
to be
correct.
adhered to, and
yeah. So let me take a question. So there is a as you are experienced banker, so do we also have a very experienced banker in our participants. One of them is Mr. Harish Prabhu, very experienced banker. He has. I would like to ask a question directly to you, Harish. Can you unmute and ask the question directly to Madam?
Sure. Yeah, good afternoon, ma'am.
Good afternoon.
Yeah, ma'am, I've been a part of, some of the UK smaller companies' insolvency processes where on the bidding side, right? Not on the sort of insolvency professional side.
Mm-hmm.
And it's such a wonderful process whereby the package, as you said, is pre-cooked and that is bought to the intending bidders. And, it's very quick and fast and only serious bidders will come and bid for it, right?
Exactly.
And now my question is, from an India perspective, while the IBC insolvency is geared to resolving the larger companies and thousands of crores, now there is a huge issue pertaining to MSMEs also, right? I mean, there are a lot of creditors of MSMEs, which include individuals, which include small trade partners, right? Suppliers, etc. and all. And sometimes, it lends into dispute and, it's like a complete nightmare.
Right.
So today, is the IBC geared to solving the MSMEs, from an IBC perspective? But the only is the silver lining is that the government has enforced, large companies to ensure that the MSME receivables are paid within a finite time frame, right? They have to make a representation.
Yeah. Right.
But how robust is the IBC code to resolve MSME issues?
In fact, if you see, the IBC code for the MSME is very liberal also. See, in case of the corporates, a big corporate rather, you cannot buy back your own company. Whereas in case of a small MSME, he has every right to buy back his own company, because once he comes to the IBC and then you have a resolution plan, he also can put in a resolution plan. So he gets a restructuring, he gets a fresh impetus to start running the unit, because many of these small MSMEs have got into problem because of certain environmental condition, certain circumstances, certain government regulations, or whatever it is. So this IBC really helps these smaller MSMEs, I think. But as of today, yes, we only talk of the big corporates, but MSMEs, I think, definitely stand a better chance in this IBC for coming out successfully and for ensuring that they are able to really withstand whatever is a pressure which they were earlier having. There will be no problems for them. And I think bankers should also take the lead. Of course, now the pandemic is there, and I think there is today also the government has announced for the restructuring. But I'm talking of the old NPA accounts, which cannot come out of this, can definitely go to the IBC. And I think there's a lot of benefits which they'll get out of it, because see, they will have a new investor coming in also.
Absolutely.
And when a new investor comes in, he's not going to run the unit. Let's be very clear on that, because he would prefer to invest and keep the same person to run the unit for him, and he will only be in the background to support him. So I think definitely it will have a lot of benefits for him.
Thank you, ma'am. Thank you so much.
Thank you, ma'am. Thank you, Harish. Once again, a good question as usual. So I have another question coming to you from YouTube by Pushpendra Khandelwal. Mr. Khandelwal asks your question, madam. Banks are asked to go in the market for capital. Do you see that in future, NPA problem is likely to become serious? And for that, what is the remedy in your opinion?
See, banks are going into capital market for capital is for the capitalization of the banks. NPA has always been an issue, but IBC is one of the areas through which you can get it resolved. That is not the only one. That's what I said. We can have some pre-packaged resolution plans which will help to do it. We can have maybe some out-of-court settlements. We can have the one-time settlements. All these are part of it. NPAs pre-pandemic was being controlled by these IBCs. Post-pandemic, we do not know what is going to happen, because today, if you see, a lot of companies do not have the demand to really manufacture also, because even if they manufacture, there's nobody to buy it from them. But NPA is definitely a cause of concern. But today, again, if you see with the banks merger, with huge public sector banks merger, there is going to be easier resolution, because instead of 3 banks talking, it's going to be only 1 bank talking on behalf of those 3 banks, number 1. Number 2, each and every bank has now formed their own stressed asset management team, who are well equipped, who are very knowledgeable in tackling these kind of accounts, and will definitely ensure that the customer who comes to them either through an NPA or through IBC, they will be in a better position to tackle these accounts and even maybe give a proper resolution and a proper finalization to how these matters should be handled. I think a lot of progress is going on in these matters also.
Okay. Yeah. Thank you. Just opinion, madam, on the so many NPAs being banks have a plan to sell it off to ARC. What's your thought on that? Is that a good thing?
I have a very different view on this ARC matter, so I would not really like to comment much on it, because I somehow feel that banks can do on their own rather than sell to ARC. But it's a very controversial topic, I would say, because a lot of banks believe that ARC will be in a better position to handle it.
Okay.
But as an individual, I feel, or as a person who was working for a bank, I feel that banks are also equally well equipped to do it. But the reason for giving it to ARC again is that they feel that an asset reconstruction company will have, will be exclusively managing those stressed assets.
Yeah.
Rather than a bank which has to also to clean up its balance sheet to some extent.
Yes. Yeah, that's true. Okay. I have another question coming to you from Nikhil Vallaban. When Nikhil asks a question, how are these changes viewed by foreign investors intending to set up shop in India? Its importance increases considering production sites are likely to move out of China to India.
Yeah, it's a very good question, and I would definitely say that this IBC is definitely helping. As I mentioned earlier, that's one of the reasons that even our ease of doing business has really improved. And one of the reasons for the IBC code being implemented in our country was that earlier that unsecured credits were not being given the benefit. That is why we are not having many entrepreneurs also setting up, because India was always, thinking only of a security-based financing.
Correct.
Once the IBC comes in and the banks are able to realize our funds, and the entrepreneurs also know that it is easier for them today to get funds, because they know the moment they default, they are going to lose a company. So nobody wants to default. So the ease of business is improved. Definitely, I think it's a very good opportunity for our country to get in more business. Of course, we should do more other things also other than this IBC code of bringing in more business by, improving our labor laws, improving our takeover of certain other, land revenues, the stamp duties, etc. Also have to play a major role in it. But I think it's a win-win situation today for India to bring in more investors, and foreign investors are definitely looking into India, and our ease of doing business has really improved. And quite a few of the state governments also promising the various foreign countries that they'll set up special units for them for these manufacturing activities.
You have
SEZs are being formed. SEZs are being formed.
Okay, great. Yeah.
The special economic zones.
So if you would look at the West, do they have something like this, what we have? Or if a company is in a problem, they simply liquidate, or is there any alternatives for them? Any thoughts?
See, generally they have only that, Chapter 11 bankruptcy, or they go into the liquidation.
Oh, okay.
If they want to go for a resolution, I think they do it out of court settlement or a one-time settlement with their existing financiers or bankers.
Okay.
And basically, if you see, our IBC code is taken more from the British style, not from the American style.
Okay.
We have more leveraged our IBC on the British way of doing it.
Okay. Thank you, ma'am. Ma'am, can you discuss, illustrate some landmark cases how IBC has been useful for the banks in tackling NPAs or recovering the money or stabilizing the company, or any such examples if you have, it will be good for the participants to know.
Yeah, you see, there's a lot of cases which have taken place, and 2-3 cases which have really been landmark judgments, I would say, which has really cleared the path so that in future you don't have any problems. One is your Swiss Ribbons account, where the court has very clearly said that the resolution professional has no vested interest in the insolvency plan, and he is to place it to the committee of creditors to handle it. And they've also upheld the constitutional validity of the IBC code, that nobody can challenge it. Earlier it was being challenged, the various high courts, that this should not happen or that should not happen.
Okay.
In the same way, if you see, they've also made it very clear that the resolution professional is only a facilitator. He is nobody. He is only a facilitator who will be supervised by the committee of creditors as well as by the adjudicating authority. And for the corporates, we know it is a NCLT who is the adjudicating authority. Also, they have made it very clear because this was a very big case which is being argued by the best legal luminaries in the Supreme Court, saying that why the operational creditor should not be given the same benefit as that of a financial creditor while considering a resolution plan, etc. The court very clearly stated that the financial creditor is definitely the one who should decide on the resolution plan, and it's the financial creditors who should form a part of the committee of creditors for the simple reason that it is they who give loans for the time value for consideration.
Right.
The operational creditor is only providing some services or some jobs, like maybe some raw materials, some machinery or whatever it is. Secondly, it is the financial creditors, particularly the banks and the financial institutions, who have the capability of assessing a unit, and they also will ensure that the unit functions as an ongoing unit and it has a proper resolution. An operational creditor is only interested in taking his money. I mean, he is not interested whether the unit runs or not, so long as he gets his money out of it.
Right.
So these were some of the things. Similarly, if you see the ArcelorMittal case, that is a SR Steel case, where the argument was because the IBC brought in the rule of Section 29A, wherein they said a promoter or any resolution applicant, I wouldn't even say promoter, I would say a resolution applicant, if he has an account which is an NPA for more than 1 year, or he is involved in any account which is an NPA for more than 1 year, cannot be a bidder in that company. So SR Steel have wanted to buy back their own company. ArcelorMittal also wanted to buy back. But the court said, even for ArcelorMittal, that you have an account in the name of Uttam Galwar, which is an NPA, where you have a stake in. The argument again was that it is retrospective effect, you cannot introduce it. But the court said, no, it can be with a retrospective effect. And one of the very good judgments, I would say, I mean, in my view, is that because these promoters cannot do a backdoor entry back into the company by buying the same company which they allowed it to go to such a bad condition, and you buy it back at, at a distress rate.
Yeah.
If you cannot run the company when you had the company with you for 20, 25, 30 years,
Yes.
Today you cannot say, no, I'm competent enough, you give me back the company at 40% value or 30% value, I'll run it back. It's not a right thing.
Yes.
That was a very good judgment. Secondly, they have clarified most of the issues in these 2-3 cases. In case of Monarch Ispat, they made it very clear that when the Commissioner of Income Tax, that as for the priorities, see, one thing which IBC we should really appreciate is the changing priority of payments. Earlier, you see, every case, it was only the government which used to get the first priority over the payments. Now they have made it that the workmen and the secured creditors, in fact, the government's priority is much below that of an unsecured creditor also.
Okay.
And even an operational creditor gets a liquidation value amount back. So a lot of cases are there. These are, and they've also made it very clear that when the court, the NCLAT said that admission date is discretionary, is directory in nature. The 14 days is directory, but for the resolution, person who's filing the case, the 7 date is mandatory. The court said you can't have it that way, the Supreme Court. Either it is mandatory or this thing. Then they brought in certain judgment. If you see the Kiruska case, where they made it Mobilex versus Kiruska, where they very clearly said for an operational creditor to file a case, he should definitely prove it that there is no dispute involved.
Okay.
There was a dispute involved and still he wanted to file the case. They said, no, it's very clear because official creditor cannot file a case unless there's a dispute, if there is a dispute already involved. He has to get the dispute cleared and then file it. So these are some of the few important judgments which have come out. And as I said, Bush and Power, once it comes out, there will be another important judgment which will pave the way for easier resolution in the future.
Yeah, if you could just briefly talk about Bush, because that's been in the news for very, very long, right? What's the problem?
Yeah, but it's only recently gone to the Supreme Court for that because JSW has already given their resolution offer, which has been accepted by the Committee of Creditors. But then suddenly the Enforcement Directorate and the PMLA, they said these properties will be attached. So nobody, see, today, if I am taking over a company, what happened 5 years back, I should not be held responsible for it.
Correct,
See, these kind of a clarity is what is required today. What happens to a contingent liability? What happens to a future contract which is already held, whether I continue with it or not? These, a couple of things, once they get cleared, I think the IBC will see the much better recovery position.
Okay. Thank you, ma'am. So, ladies and gentlemen, you heard some of the good cases of what the IBC has helped. So let's take another question. It's a question to you coming from Srinivasan Krishna. He says, ma'am, is it good for the smaller banks to form a consortium? Will it be beneficial for them?
See, first and foremost, I would say that smaller banks, generally today it will be very difficult for them to go into a consortium because RBI does not allow you to give any loan below 100 crores if it's going to be a consortium. And a smaller bank, depending on what is the size of the bank, whether they will be in a position to take that kind of a limit. Secondly, a smaller bank, see, a bigger bank, what happens is in a consortium, a smaller bank will generally not get hurt. It's only the big banks who will be able to be the big brother. And then the smaller banks will just be forced to nod their head. And even in the COC, ultimately, let's go to COC also. 66%, so the small bank will not have such a huge percentage. So my suggestion would be for the smaller banks, they should go independently for funding, or let them go for a multiple banking if the need comes to, so that they have their independent security. They are not dependent on the big brother for getting any of their results, recoveries, and they don't have to fall back on the big brother otherwise.
Okay. I have another query coming from Prabhu. He says, I presume that the IBC maps the same principles of resolution in terms of the earlier liquidation scenarios, that is, the insolvency professional fees, senior, secured, unsecured debt, preferred debt, and then finally equity. Is there any difference in the earlier and current scenarios?
See, in fact, the present scenario gives you the benefit because earlier scenario, even for the liquidation prior to the IBC, the government dues were ranking much above the unsecured creditors.
Okay.
Today, the unsecured creditors get a same level as that of the government dues. In fact, if you see the waterfall mechanism, the first is the liquidation cost or the insolvency process cost, whichever it is going to be. The second is going to be the secured creditors along with the workmen. Third will be the other employees. Fourth will be the unsecured creditors. The fifth is going to be your Government of India along with the unsecured portion of the secured creditors.
Right.
And then comes your other stakeholders. And in fact, this other stakeholders also come before now because you have the other stakeholders which have been introduced now. Because even a person who has taken a house, and if he is not given a house, he also can go to the court as a financial creditor.
Yes, correct. And we talked about some of the cases which you very well put across as to what happened in these cases. And so my question to you is, what are the success mantras for the banks resulting from the cases that some of the cases that you talked about? What are the success mantras for the banks?
See, the success mantra, if you ask me, is that basically many of these cases, big cases, have been able to get resolved. And that has been possible because, the 42% recovery which has happened could not have happened but for the fact that these IBC cases were there, because otherwise there was a lot of delays. But even today, I think if you're able to do a proper due diligence, I think the success rate can improve. And the post-implement, see, the most important thing, one more thing which we should realize is not only the approval of a resolution plan.
Yeah.
Approval is one thing. How it is going to be implemented. If you see earlier also, the big companies like Liberty House from UK and all had bid for it. In the last minute, they backed up. Because implementation is not as simple as just bidding for it.
Yeah.
So that is one of the things I think the bankers have to keep in mind before they even entertain such applicants, is whether they will have the wherewithal after bidding for it to implement it. Of course, the resolution professional also plays a important part of it, but implementation is very, very important for it.
Yes, of course. Yeah, execution is everything, as they say.
Every execution.
Yeah, absolutely. So I have a next caller, call coming all the way from Chennai to you. Mr. Tyagarajan would like to ask you a question.
Very good afternoon, madam. This is the context of insolvency to turnaround. The question is, in the event of a creditor gets hold of a company, can the creditors appoint a professional from the market to turn around, raise capitals with targets and timelines? And can this also be carried out for a government or a public limited company? What's your views?
See, there is no restriction as of today which says the insolvency professional who is appointed. Anybody can say that I'm going to bring in the capital. But even if he brings in the capital, let us presume X, Y, Z, whether he has the capacity to run the unit, then he has to bring a full package along with him. As of today, see, the public sector undertakings are all that of the government, public sector. But other public companies, anybody can take over that company. There is no restriction today from the IBC or from the government or from the regulator for an individual to take over the company, subject to the fact that he has a financial capability of raising the funds, how he has raised the funds. That is again very important, because there should not be a 3-layer, 4-layer way of raising the funds, and how he is going to implement it once he is in charge of that particular company, whether he has the experience, the expertise, or whether he will be able to get that many people to run the unit is what is to be seen. But there is no debar on such a thing as of today.
Thanks.
Thank you. Okay. So, ma'am, how does the IBC deal with cross-border insolvency resolutions? Inside the country is one, but if it is cross-border, how does that resolution process? And it's dealing with foreign creditors, claims, and assets. What are your observations from so far from the insolvency proceedings of? We have one case of Jet Airways under the IBC. So if you could talk about how the cross-border works in this case.
Yeah, see, there are two aspects to the questions which you have raised. One is a creditor from abroad can definitely, if it's a property is only in India, he can come to India and file a case, which has already been there in the case of Macquarie Company Bank, where they had given some letter of credits, and matter was dealt with, and they had the right to claim it. In the case of cross-border insolvency, actually the government or the IBBA code has not come out with anything. But in the case of Jet Airways, frankly speaking, what had happened was that the State Bank of India had filed a case in the court in India. At the same time, in Holland, a case was filed for bankruptcy, and whereas we had filed for resolution here. Since then, the matter has been decided by the NCLAT. It is not by the IBBA. The NCLAT has had called the Dutch person here, the company here, told them not to go for bankruptcy. There has been an agreement which has been signed by the resolution professional of India and the Dutch person, stating that they will participate, that is, a Dutch group will participate in the meetings which are to be held for the resolution here, though they will not have a voting right, and subject to of course, the guidelines being permitting them to take part here and all that, which they have agreed that they will take part here. And this is one of the real landmark judgments which has been taking place. Of course, a resolution has yet to take place because there's hardly anybody who's willing to take over the company.
Yes.
Because of a lot of other issues in that. But cross-border insolvency as such has not come into play. But in this particular case, NCLT has taken a decision and an order has been passed in the month of September 19 that before they take any decision abroad for bankruptcy, they will take the prior permission from India and then only do it. But they have agreed that they will take a part in the resolution process here.
Okay. So the countries have to sign a kind of.
Not the countries, the company which was planning to go for bankruptcy.
Okay.
They have signed an agreement with us, with the resolution professional or with the person. Because
Okay.
IBC code has not, as yet, come out with a full-fledged cross-border insolvency program. I think it is in the pipeline. Hopefully, it will get done shortly.
Okay. So, ma'am, the government came with this decision to impose a 1-year suspension on fresh initiation of corporate insolvency proceedings under IBC. Recently, they came out with this. So, from your experience of almost 4 decades, how does it help in reducing the burden of stressed assets on the banking system? And why was this suspension has come? What is the reason? What is the rationale for that?
See, it's very, I mean, it's the government of India has come out, so we are not going to say why it has come out. See, they might have come out because of the pandemic, I feel, but actually, frankly speaking, see, an account which is, if it was to go to the IBC in the month of March also, that means the account has been in stress from January 2019. It is not that the account has come into stress from March 20.
Yes.
If the account had come into stress from March 2020, anyway, there is a freeze on classifying any account as a substandard asset with effect from March 2020 if it has been standardized on that date. So these accounts which would have come to the IBC were all accounts which have been an NPA for more than a year plus.
Yeah.
So the logic behind it is really difficult to understand. Of course, the government must have had some think tank telling them why it should be done.
Yes.
But I personally feel had it gone into IBC, I think that company would have stood a better chance of recovery. Because once an MSME particularly goes into an IBC, the chances of it getting restructured, the chances they'll have a calm period of 180 days where there'll be no litigation, they will be able to get all the essential services, there will be no disruption in their essential services of electricity, telecommunication. I think that would have been much better for them to really come out of the stress. Because the restructuring would have been easier for a committee of creditors to do it, rather than for doing it outside the committee of creditors. But government must have heard about it. But personally speaking, I think this suspension is not really required, and government, I think, should have a rethink on it. And maybe, in fact, if you see a few days back, even Mr. Viral Acharya was of the view that we should, lift it maximum. We should keep it maybe for another 3 months or so. But after that, the IBC should be back in force so that the good accounts resolutions can take place at a faster pace.
Okay. So it's probably because of the COVID times, is it?
Exactly. But actually, as far as COVID is concerned, anyway, I don't know, because fresh accounts are not going to be taken. It's only the old accounts which should have been taken up.
So, okay, there must be some reason, I guess. Another question I have for you, which has come from a participant is, ma'am, it says the code creates an insolvency and bankruptcy fund, but it does not specify the manner in which the fund will be used. Any thoughts on these?
No, actually, code is very clear. There are two different kinds of funds which are there.
Okay.
One kind of fund which is there will be used for the salary, etc., for the people who are running the company. Correct. The second one is where even sorry, even a good corporate, a standard corporate can contribute to that fund. And tomorrow, God forbid, he were in such a situation, even he is permitted to withdraw equivalent to the amount of what he has deposited for payment of salary, etc., to his employees. The fund is very clearly mentioning what is to be done for what. So I don't think there's any problem. And in fact, only the additional fund after the liquidation, after settling everything, if something is left out, it goes back to the insolvency fund. There are two different funds actually, which are there.
Okay, fine. Thanks. Ma'am, are you okay to take a couple of more questions? It's already
no problems. No problems.
So the code provides an order of priority. We talked about this, right? That how it should be done. Right? Order of priority to distribute assets during liquidation, but it is unclear why such a priority has been given as per the participant who asked this question. The secured creditors will receive the entire outstanding amount rather than up to their collateral value. Okay, so I think that's very important to know. The secured creditors will receive their entire outstanding amount rather than up to their collateral value. Unsecured creditors are priority over trade creditors, and the government dues will be repaid after the unsecured creditors. What is the rationale behind such priority?
Yeah, see, the rationale behind the priority is basically, if you see, the secured creditors are who? The bankers. The bankers are basically the secured creditors. And if you see, it's not a collateral. See, the bankers are the ones who are funded even for the primary security, whether it is a current asset or whether it is a receivable, whether it is stocks, whatever it is. And naturally, see, collateral is just, if a company has got a 100 crore limit, the collateral will hardly be 2 crores or 3 crores. So you can't say that why are they being paid the entire 100 crores. And if the secured creditor is getting the full amount, that means the company is doing well. It's very rarely that the secured creditor gets a full amount, because in most, till now, except for one case, I think of Binani Cement, which I know of, where the entire dues have been paid. Other than that, I don't think any account which has come to the IBC has got a, I mean, most of them have got a hit of at least 40 to 50%.
Okay.
And the reason why a trade creditor is kept below that of a secured creditor or the government, you see, I think one thing we really should appreciate is that the IBC code, that is a Banking Law Reforms Committee, made it very clear that the government due should be lower in priority for the simple reason, if the company runs, the economy runs, and automatically the government continues to get money from the next person also. Whereas if the company, if the government says, I'll take all my money, the company is it's going to be a debt concern. Nobody is going to take over that concern, because the liability, the government liabilities will be huge.
Yes.
So I think it's a very good decision taken that, and I think the priorities, in fact, have been very well laid out.
Yes.
That everybody gets an equal share and there's nobody who missed out. In fact, if you see in the resolution process, if in case a dissenting creditor is there, he and the unsecured creditors are first paid before the secured creditors resolution plan is implemented. So the dissenting creditor also gets a payment. So I think they have been very clear on these things.
Yeah, I think that's the priority of the government getting the last is, I think it's
really
welcome.
Good.
Yeah. Otherwise in earlier times it was always the government gets first.
Yes.
Right? Because they want their dues first, and then the companies like
company goes to the doldrums.
Yeah, absolutely. It is. So I think it's a great priority setup. Thank you for asking the question. And my final question to you, ma'am, is skeptics say that IBC helps the banks to make their balance sheet clean. And when bad debts or NPAs are brushed under the carpet after the IBC resolution process is over. But then banishing the problem is not the same as finding a solution. What should banks do to prevent NPAs?
Okay, I'll take this question into two parts.
Yes.
One is, see, by going to the IBC, I only go for an NPA account. And once I get resolved an NPA account, is actually a cash flow for the organization.
Yes.
So that much of actually cash or whatever it is comes into the system, and that is how a part of my balance sheet gets clear. I fully agree that yes, NPA is a major problem and nobody is brushing it aside. For that, I agree we have to do more of due diligence. It should also be ensured. That is why if you see again in the East, which has been formed by the government of India, they have made it very clear today that there will be different verticals for different activities. Earlier, the same person was, pre-sanctioning the loan, he was considering the loan, he was doing the post-sanction, he was doing the follow-up. Now they have made it very clear that there will be separate verticals, one for pre-sanction, one for post-sanction, and one for follow-up. They've also made it very clear that for big projects and for big accounts, there will be an external independent agency who will monitor those accounts on a regular basis. There will be more meetings of the consortium to ensure that the accounts are really in order. And there are a lot of other systematic things which have been planned by the banks themselves. Because today, let's accept one thing is with the various benefits of the digital banking available, there are a lot of things which they can immediately find out which account is in stress and which is not in stress, which was not possible a few years back.
Yeah.
So these are some of the steps which are taken. And yes, it is definitely a problem. See, any industry, let's know one thing is any industry will definitely face problem at some time or the other. It is a cycle.
Yes.
For that, we cannot stop lending. yes, due diligence has to be done. That is all I can say.
Thank you, ma'am. Thank you very much. I think, ladies and gentlemen, I hope you've enjoyed this conversation that I had with Madam Latha. She's a very, very experienced banker, and you must have, how she answers every question and puts a kind of a process step by step. And that's the hallmark of a great experienced banker. I have met many such bankers, and they exactly know what is how to put it through step by step. And I really enjoyed discussing with Madam Latha. And Madam, thank you very much for coming. Participants, I hope you enjoyed. I just leave this final 2 lines before I sign off. Because of the introduction of IBC, it makes the doing business in India easy after the unification of several insolvency laws. It promotes the entrepreneurship and tries to balance the interest of the various stakeholders. Its introduction is really a revolutionary step as it provides the benefit to the Indian capital market. So with these, I sign off. However, before we say goodbye to Latha, may I remind you, tomorrow is also another very good special session like we had today. We are having specific, we are talking about ATM industry, something we haven't covered much across the globe. The speaker is Dr. Aravinda Korala. Topic is revamping ATM industry for profitability. He will be joining us from London. A lot of audience from the European side, Europe, UK and US and other major economies are going to join us. They have committed that they will join us for this. So don't miss the session. It's going to be very, very interesting. Madam, you also please join us for this session tomorrow.
Sure.
And permit me to say goodbye to you along with all my participants.
Yeah, I would like to say thanks to Mr. Mani Mamallan. I would like to say thanks to you, and I would like to say thanks to Mr. Vivekananda for having invited me for this session. And I really enjoyed interacting with all of you. Thank you very much.
Thank you. Thank you, ma'am. I really enjoyed interacting with you. I hope to have you in some other session after a few days. Thank you so much. Have a good evening.
Thank you. Same to you.
Thank you, participants. Have a good evening for the rest of the day.